Administrative Decisions from the USPTO for the Intellectual Property Research course at Boston College Law School. Procedural matters relating to the denial of a patent or trademark can be appealed to the Commissioner of Patents or the Commissioner of Trademarks and were reported in decisions of the Commissioner of Patents from 1869 until 1968 when they stopped publishing those books. Decisions published in those books are available to us in Hein Online in the Intellectual Property Law Collection. Select Federal Agency Decisions and scroll down. Use the link to Decisions of the Commissioner of Patents. This is the title page from the 1968 volume. Today, USPTO decisions are available on the PTO website in part because of the Freedom of Information Act. So scroll down to the bottom of the home page to take you to the Freedom of Information Act link. The Electronic Freedom of Information Act Reading Room provides links to the administrative decisions of the PTO. So let's start with the Commissioner of Patents decisions. Final decisions from the Commissioner for Patents are organized by topic, linking to the decisions on the subject of patent term extension or adjustment under 35 U.S.C. 154. We see these decisions are in patent number order. Let's look at the decision from March 1st, 2019. It looks a lot like a letter. The body of the letter is divided into background, calculations, and a conclusion. It was signed by an attorney from the Deputy Commissioner's office. Moving from patents to trademarks, we see that the decisions on trademark petitions to the Director cover representative decisions on routine issues but are not precedential. They are grouped by type of petition. We're looking at the detail of petitions to reinstate a canceled registration. The serial number link retrieves that record from the Trademark Status Document Retrieval Database. Under the Documents tab, click on Petition to the Director Denied or Petition to the Director Granted to see the decision. This decision of the Commissioner of Trademarks is divided into facts, discussion, and decision. It's signed by an attorney advisor from the Office of the Deputy Commissioner for Trademark Examination Policy. Final decisions of the Patent Trial and Appeal Board from 1997 to date are available on the PTO website. PTAB decisions are designated as precedential or informative. In the left-hand column is a link to search the decisions, but they are also browsable. Decisions are organized by subject matter in an expandable table. Under each subject, decisions are classified as precedential or informative. Let's look first at an informative decision and then a precedential decision. PTAB opinions look a lot like court opinions. Informative opinions are not binding but illustrate norms of board decision-making. This decision is very clearly marked as informative at the top. Opinions designated as precedential are binding on the PTAB. The purpose of a precedential opinion is to create a consistent line of authority as to a holding that is to be followed in future board decisions. Precedential decisions are clearly labeled as such. There is a link to this PTAB Final Decision Search page from the PTAB Decisions page, the Precedential and Informative Decisions page, and the eFOA Reading Room. To look at a representative decision, we'll click on Retrieve Decisions from the last 30 days. Search results appear in a table. The asterisk in the Decisions Date column indicates that this list is sorted by decision date, but you could resort by any of the columns with arrows in them. This was the cover letter that appears at the top of this appeal decision. This decision on appeal looks quite a bit like any reported decision from an appeals court. Some are short, some are long. The names of the administrative patent judges appear at the beginning of the decision, unlike the decisions of the commissioners. Final decisions of the Trademark Trial and Appeal Board are also available in a searchable database accessible from the eFOA Reading Room. The sortable columns also represent searchable fields of this database. Again, only those decisions labeled as precedential are binding on the agency. The TTAB can only determine the right to register, but not the right to use. The TTAB is also responsible for cancellation proceedings against registered marks and concurrent proceedings usage.